me code. I am number 63590, Sergeant Samuel Itegi. Your Honor, maybe just to save the cost time, because I already supplied the respondent with a miscellaneous application, I'd wish maybe to adopt the same and be granted the days that I paid for. For 10 days. To allow me to proceed. And this is also stated in my supporting affidavit, Your Honor.
I'll confirm that what you're praying for is as follows.
Yes. Yes, that is it. No, it is on 20. Oh, sorry, Your Honor.
Which application supported by an affidavit sworn by number 63590 Sergeant Samuel Itegi on the dash of June? So it's not dated.
Yes, there's a stamp showing it's on.
Is it dated? No stamp for the official counsel, they stamped it, but is it dated? The application,
yes.
On the face of the application. So your grounds are that?
That I be granted 10 days. Yes, I'm praying for 10 days, Your Honor.
What are you praying for? What 10 days do you want for?
Yes, and maybe. Yes.
That you're praying for 10 days?
Yes.
Can you read it?
Yes, I'm saying that I want to be granted 10 days so that I can sub the exhibit funds for forensic analysis, obtain bank statements and M-Pesa statements, record statements from key witnesses.
Okay, number 63590 Sergeant Samuel Itegi.
Yes.
You go to your application is brought under the provisions of the Constitution.
Yes, Your Honor.
Stated above is premised on the grounds that one.
The first one. The respondent was arrested on 25th.
Go ahead.
Day of June 2025. One was arrested at Mudurwa. The other one was arrested at yes, at Locks in Kayora, Your Honor. They were booked, Your Honor, as per the OB number 3 of 2025, of 25 June 2025. The other one was booked as per the OB number 4 of 25 June 2026, Your Honor. That foreign intelligence report, Your Honor, that there was a circulation of a timetable on various social media platforms with inflammatory and inciting messages, Your Honor, urging members of the public to attend a protest march whose aim was to unlawfully take over and occupy State House on 25th of June 2025, Your Honor. I can continue. That the publication was traced to X account at Dagwin before it went viral on various social medias, Your Honor. The respondent are believed to be part of suspected individuals We plan to inflict peaceful demonstration organized by young people for Gen Z to engage in unlawful act of stealing from shop, assault innocent citizens, promote political ideologies that undermine security and stability of the country, Your Honor. That the criminal activities were well planned and funded by the network of the suspects that include the respondents and others who are still at large and are yet to be arrested. The respondent and other mobilized people with the intention to steal, breach the security at the State House, then breach the Public Order Act and the Protection Area Act.
You missed something? Is that also part of the application?
Yes.
A national security asset, what does that mean?
Yes. That's regarding the breach of the Public Act and the Protection of Areas Act, Your Honor. Protected Areas Act. That the continuous publication of such material on the public social media pages has led to violation, foreign agitation by general public, and what has impacted negatively, and is now threatening national security stability, Your Honor. That it is necessary to have the custodial respondent to assist with the investigations, which are incomplete, which are complex in nature and require several interviews with respondent as the new investigations lead emerge. That being the mobilizers, the respondent, if released, may interfere with the potential witnesses who are yet to be interviewed and their statements recorded. That investigations are not yet complete and I am seeking to hold them in order to subject the exhibit 1 to forensic analysis, obtain bank statements and investor statements, record statements from key witnesses in the investigation, Your Honor. That I require 10 days to complete the investigation, Your Honor. That is my plea, Your Honor.
Any counsels? That's your maiden.
Yes, yes.
The court is honored to have your maiden appearance before this court.
Thank you, Your Honor.
And
Much obliged. Yeah.
welcome to the profession.
Which primarily is premised under the provisions, the investigating agencies the right to continue holding an arrested person past the 24 hours period if they are able to, Your Honor, demonstrate before court under 36(5) that there are compelling reasons to believe that the suspects shall not appear. Secondly, Your Honor, 36(5)(b), that it is necessary to keep the suspects in custody for their protection. Or C, that the suspects are serving a custodial sentence. And B, that the suspects have previously been arrested in relation to commission of an offense. Your Honor, we can confirm that this is the first time they're being arraigned, so that they are of good character. But more importantly, Your Honor, the suspects that have been presented before you are citizens of great repute. Your Honor, the second respondent, Robert Otiti, is a former Kenya national team Harambee Stars captain who led the country to a historical 14-0 win against Somalia, while Mr. Suleiman Wanjau is a known boxing trainer whose community service at Mudhurwa and Makongeni area is known, where he is a known trainer of boxing. But of importance, before this honor elicited a lot of national attention and interest, Your Honor, is that the grounds of the application is premised on allegations of false information of the respondents, publicating and spreading false information contrary to Section 23 of the Computer Misuse and Cybercrimes Act. Your Honor, if you look at ground number 3 in support of the instant application, it is alleged that our clients, the respondents, circulated inflammatory and inciting messages urging members of the public to attend a protest march whose aim was to unlawfully take over and occupy State House on the 25th of June 2025. While that is an allegation that would be best fit to be tested during trial, what has caught our attention is a subsequent paragraph, Your Honor, that is paragraph 4, that avers that the publication was traced to an X account at Daguin, that's double D, before it went viral on various social media platforms. Your Honor, the reason why it is important for this court to take notice of that judicial notice of that particular paragraph is that there currently subsists or filed before the High Court, the Constitutional Court, under High Court HCCR petition E387 of 2025, a petition in the nature of a habeas corpus application, 10 days in further violations of their rights, and there have been not presented any compelling reasons as to why they seek the continuous detention of the suspects. Your Honor, I'll be ceding the floor to Mr. Wino, who will extrapolate on the grounds regarding compelling reasons.
Your Honor, to reiterate on what my learned counsel has talked about, that the accused persons were arrested on the 24th day of June, and they are being presented before you on the 26th day of June, which is infringing on the rights of the accused persons, because, Your Honor, Article 49 of the Kenyan Constitution states clearly the rights of an arrested person, that an arrested person must be produced before a competent court of law within 24 hours, and further, that arrested person has a right to bail or bond. And Your Honor, you see the two accused persons having been arrested from 24, they were denied even a police bond, knowing very well that they are persons who are known, well known in this country. And therefore, Your Honor, we are being told by the investigating officer that they have an application before you, a miscellaneous application, to further hold the accused persons for 10 more days. Your Honor, it's like we are doing things in a very opposite way. Because the right way to do things according to the rules of natural justice is to investigate an offense or a crime and then make an arrest. The IO was not even sure of the type of an offense to investigate because they arrested first, then they come before you, Your Honor, with very flimsy reasons. They are on a fishing expedition to tell you that you allow them, that you be part of infringing on the rights of the two accused persons, that they want to hold the accused persons for a further 10 days without proper reasons. And that the first reason they are telling you is that the accused persons is that they want to subject the exhibit, which are the phones, to forensic analysis. Your Honor, this can be done even in the absence of the accused persons. And if you look at the phone, the type of phones that the accused persons are using, Robert, being the first accused person, the first suspect, is using a Nokia Kabambe. Nokia Kabambe, Your Honor, has no capacity. You can't access internet using such type of a phone. And the second suspect, Suleiman, is using Nokia C1, and this person is not on X, he's only on Facebook. And what is brought? Nokia C1. Nokia Kabambe. It's Nokia C1.
It's the other way around.
Yeah. So Suleiman is using Nokia Kabambe, and Robert is using Nokia C1, which has only the potential, is only on Facebook but not on X. And the case brought before you is a case that is speaking for a matter that was fished from a platform called X, which is a social media platform. We are also being told that they are waiting to record statements from key witnesses in the investigation. Your Honor, since when? Because we ought to have assumed that they've finished with their investigation, they are bringing a proper case before you. And they want the suspects to be present when they are recording statements from key witnesses.
Who ideally are mostly police officers.
And, Your Honor, the same IO, investigating officer, said very well that these two suspects are capable of interfering with the witnesses. And the witnesses that we always have in such cases, Your Honor, are always police officers. So we ask ourselves, Your Honor, that the other day, there's a suspect who was arrested in a police cell, Albert Ojuang, was arrested, put in a police cell, and is alleged that he was killed by a police officer. And therefore, Your Honor, if we leave these two suspects in the hands of the police officers, they are dangerous people. Because they are supposed to protect life and property, and it is alleged that they took life and property. They took life, sorry, and also property, because some property of the arrested person were missing. So therefore, Your Honor, this is a police officer. These are police officers who are armed. You are being told, Your Honor, and the state is wasting the court's resources by us sitting here a whole day. You're being told that these two gentlemen can interfere with police officers who are custodians of guns. And even if they were capable, which they are not, we have witness protection that can take care of this. And they are not proving the compelling reasons why the suspect should be held for a further 10 days. And Judge Ibrahim, as he was then called, in a case of the Republic versus Danson Ngunya and another in 2010, described a right to bail as inalienable right by holding that for you to prove compelling reasons, you must show that there is exceptional circumstance. In the case of the two suspects, there is none. Or unusual. This is a very usual case, which to some point was also declared unconstitutional, depending on how they will prove their case. And ordinary circumstances. And extraordinary circumstances, sorry, which is strong, rousing, interest, attention, conviction. None of this, Your Honor, is watertight to justify the two suspects being held by the police officers. Another reason, Your Honor, we are being told about antecedents. That the two suspects were arrested before, that they are habitual offenders. Your Honor, you know very well that every case must be treated with its own facts and merits. And even if they were convicted, which they were not, in the previous offenses, which they don't have, they've never been arrested, then it means that they already served. They already dealt with that case. And this is a fresh case that is before you, Your Honor. And this reminds me to bring to your attention a case of Mills versus the Queen. A case of contemporaneous similar fact evidence. That Mills used to commit an offense, used to murder children in a bathtub and bury them around the house. Mills was arrested, charged with murder, served. Then another time, Your Honor, Mills, I will provide it, but it is common law, Your Honor.
Common law precedent.
The common law precedence. So, Your Honor, to drive my point home, there's a time that somebody else killed in a similar way, but the authority went for Mills, arrested Mills, charged with murder, was convicted. But on appeal, it was found that it is not Mills who killed, or he was wrongly charged for that matter. So therefore, antecedents does not apply here. Another reason that we could be told that the two suspects are flight risks. Your Honor, the officers, police officers, arrested the two suspects from their houses, which means that they are aware, they know that they have a fixed abode. We can't be told that they don't have somewhere to stay or somewhere they'll be found, or they will run away. And Your Honor, even if that is the case, then the two suspects are Kenyans. They can deposit their documents in court, or they can report to the nearest police station depending on the direction that the court may deem fit. Therefore, Your Honor, as I finish, I want to say that this application, the IO is on a fishing expedition. The application is vexatious. It is lame. It is flimsy. It is limping. And it is an abuse of the court process. Thank you, Your Honor. And I request the court to release the suspects on a free bond. Thank you.
Chabi Otieno. Your Honor, is presumed to be blind and deaf and only acts on the evidence that is adduced. I had the benefit of looking at the application before you. And Your Honor, I like to state to this court that there is no evidence from paragraph 1 to the last, to the 14th in the supporting affidavit. Your Honor, we wish this court to treat these averments, statements, and record statements from the key witnesses in the investigation. And their father went ahead to indicate that the suspect no evidence that has been adduced before this court are pertinent to this application, to indicate that the drafters of this application, how are they intending to lead this court to believe court is at a loss? As counsels are representing the suspects, we are at a loss because there is nothing that is substantive or that is material in the applications. What therefore means that this application has only one fate: to be dismissed. And we would also be praying that it be dismissed with the costs. Or the state should pay the costs.
Your Honor, I'm John Minor, with what my colleagues have said, and draw you to the case of Oscar Sudi versus Rick. It's so amazing that the investigative officer came here full of apprehensions for that matter, that the respondents, if granted liberty, would impede from collecting his call register or even getting statements. Your Honor, the IO has not laid before this court any material evidence.
This Mativo in 2016, in the matter Republic versus Danford Kabage Mwangi, proceeded to enumerate the factors that a court sitting in a position that you are sitting now should consider while considering the factor that the accused or the suspect should be given a cash bail or not. And Your Honor, in the Mackenzie case in 2020, the court in Shanzu, your brother was sitting where you're sitting now, and he considered all the factors that were tabulated before him, and he proceeded to say that these factors should not be mere allegations, they should be accompanied by evidence or proof. You know what you see today is a mere affidavit. It has not been attached anything thereto. As such, there is no documentation to ascertain that indeed what is being said is not a mere allegation. Jonah, it is not in dispute that there are suspects before you are persons known to the police. In fact, as stated by counsel before me, they were arrested in their houses, in the company of their family. It is therefore not difficult to trace these persons. Jonah, on this front, we pray that the court may deem it fit to grant the suspects a lenient cash bail and bond terms. We are not objected to them having conditions for them to comply with, such as perhaps reporting to the DCI offices as and when required to do so.
The suspects were arrested. Where were they put? Where have they been? And I'll still ask, taking judicial notice, have you felt safe?
Yes, we were handled well there.
You were handled well there. You can confirm that you are handled well.
By the Capitol Hill police, we were handled well.
You are and
But
you
the
felt
ones who
safe.
arrested us,
Mm.
they brought their lives.
Mhm.
Those who were
Kindly
arrested-
stand. Kindly stand.
Sorry. Like the ones who arrested me, they instilled fear even then to the people who saw it, because they came with 5 vehicles, 4 Subarus and 1 Probox, and they were heavily armed as if I'm a terrorist.
Okay.
Yes.
But you're safe. You felt safe at Capitol
I
Hill.
felt safe.
Okay. That is your Robert Otiti,
Yes.
Elwaka,
Yes.
and Suleiman at Capitol Hill.
Yeah, I feel safe.
You felt safe.
But wakinichukua kwa nyumba,
Mm.
nilizochukua sehemu nyingi, nikaambiwa wewe mtu fulani. Ndio waliuliza kule nje. Gonga. Sio mimi nilikuwa na watch ball kwa nyumba. Hii one club. Nilikuwa Bayern Munich versus na timu fulani. So walikuja tu wakaniambia unaitwa na mdusi. Kutoka nje yake hakuna mdusi.
Okay.
Walikuwa wengi wako armed. So mimi ile heshima nikashuka kwa barabara hapo hiyo kuingia campus. Jumla ka hiyo land opposite ni Nasipo. So mimi nilikuwa kwa boot.
Okay.
Na gari ziko ine nikapelekwa.
Na mulishikwa lini?
Simu yangu mpaka sasa hivi familia yangu.
Ni sawa, lakini ilikuwa ni siku gani?
Yeah.
Ulishikwa lini? Tuesday, tarehe 24.
Yeah.
Alafu na Elwako ulishikwa tarehe
Ilishikwa hiyo
24th pia.
24th.
Okay.
Is from the DCI headquarters, not from Capitol Hill Police Station. When I interacted with the first suspect, Suleiman, he suffers from diabetes. When I further interacted with Robert earlier today, he told me very well that they were also traumatized. And Your Honor, you know, if you stay in a police cell from 24th to 26th without being produced before a competent court of law, and we know of the recent happenings. What happened to Robert Ojwang?
Albert.
Sorry, Albert Ojwang. You might not know, Your Honor, these two suspects, God forbid, might even pass at the cells because of depression. Thank you.
This is the ruling of the court. Now, this court, on the onset of reading the application and hearing counsels for the suspects and the defense, deems that this matter has key issues to be addressed. Now, these are the following orders that the court has made. That the suspects, having interrogated both suspects, be put at Capitol Hill Police Station today, and I'll deliver a ruling tomorrow, the 27th day of June 2025. These are the orders of the court. Okay? So I would want to assure and I pray that you will be safe until tomorrow. I take judicial notice of the sentiments by the counsels, and I will give a ruling tomorrow, the 27th day of June 2025. Interim, in case you need any medication, that should be accorded to you. It is a right, it's a human right issue. And then you come here tomorrow, the 27th day of June 2025. Okay? I'll give a ruling then. Yes. You let me know.
Very well.
Okay, fine. That should not worry you. Okay? But wish you well. Okay? You will be well. You will be fine. Are there any other issues or any other pleas before the court? None?
Miscellaneous application to break the top 10 Mohamed Ali Wario.
None. Where is it?
I was given the file list. Maybe you can get it now.
We are ready?
Thank you very much, members of the press. Today we are here as advocates, together with advocates from the Law Society of Kenya. We are here with Advocate Abner, Counsel Chabi, and Counsel John Maina. We've been here from morning until now, waiting for some of the Kenyans who were arrested yesterday as a result of demonstration, which we clearly know that Article 37 of the Kenyan Constitution states clearly that every Kenyan citizen has a right to peaceably picket, demonstrate, assemble, and or present petitions. And therefore, from morning to now, the police officers have refused to present these innocent Kenyans to court. We demand from the IG, Inspector General of Police, to either release these Kenyans unconditionally or present them before any competent court of law. Because as things are, we are not safe even in the hands of the police officers. Going by the case that we had, the case of Albert Ojwang, who was killed by police officers in a police cell, the same officers who were mandated to protect lives and property, but they take lives and they were also seen taking property. That is the case of the laptop. Today, we were further representing two Kenyans, Suleiman, Bilali, and Robert. These two Kenyans were arrested with an allegation of publishing false information that they were inciting the public to march to State House, which we don't see anything wrong with that, because they were simply telling them to go and greet their president. And the president is a public officer, is a state officer. So going to greet him, for him to prepare even tea, lunch, and supper for these Kenyans is not a wrong thing. So the ruling for this matter, because the DCI has made a miscellaneous application on this issue. The ruling will come out tomorrow morning, and we pray that they will be released on personal bond, because the miscellaneous application made by the DCI is vexatious. They are on a fishing expedition. It is limping. It is archaic. It is abnormal. So these Kenyans must be released. On the issue of one of our own who was abducted, Mr. Daniel Ndiamui was abducted, and we still don't know where he is up to now. Mr. President, you promised Kenyans that abductions will be a thing of the past. Keep your word. We want Daniel presented dead or alive before court. I will welcome other counsels to say a word.
Yes, thank you very much, the ladies and gentlemen, from where Counsel Babu has left. With the very detained these two Kenyans for a further 10 days for reason of alleged publication of false timetable, false publications linked to a timetable that was posted on an X account, that is Ndiamui DD. Now, it is quite ironical that the owner of the said account, that is Daniel Ndiamui, his whereabouts remain unknown, despite the fact that the police themselves took an inventory of items that they collected from his apartment, despite the fact that there is a missing persons report at the Kino police station. And now further, and very apparent today from the application before court, is that the DCI seeks to continue holding these two suspects on allegations of activities that were, or posts that were made using Ndiamui's account. So we ask and push for the forthwith release of Mr. Ndiamui. The Law Society of Kenya has equally filed a habeas corpus application, and we will be hoping to see directions from the High Court today as to the compelling of the Inspector General of Police and the DCI boss, Mr. Mohamed Amin, to come before this honorable court to explain the whereabouts of this innocent Kenyan who was taken away on the 21st day of June. This is now 5 days later. So we push for his release unconditionally. Or if they have any charges they want to present against him, let him be brought before a competent court of law. That would be all. Thank you. But based on fact and evidence, we have indeed submitted to court. And that's why I think Mheshimiwa Babu has said, this is a baseless. It is meant of mere conjecture, a peradventure, or innuendos. Because the gentlemen bear kabambes. Number two, it's only Robert who has a Facebook account, and his last post was last year. Mr. Robert should be treated as a hero. This was a former captain of Harambee Stars, and the only time when Harambee Stars have ever had a win of 14 goals to nil. Now that is how we are treating our heroes. Mr. Suleiman is a boxing coach. He is engaged in social activities in Mudhurwa, yes, and Makongeni. He's training young men to use their good time in, having actual hobbies that are helpful and a way of exercise. So these are actual patriots, and the reason as to why they have been arraigned and they seek to hold them for another is totally unjustified. Totally unjustified. And we are expecting that the Honorable Court, as the defenders of justice, to hold forth and stand firm to this abuse of court processes and or the law or power.
Yeah, what is more shocking, if you